Financially raw, real, authentic wisdom with Lawrence Oberholzer from Retire Rich and Happy.
So what are we going to talk about today? The discussion points for today is why you should have a will. So why should you have a last will and testament? And if we have some time, I will also talk about a few of the more intricate points that you need to look at when you do draw up your will and testament. And this is a very, very important thing, especially where we are in the era that we live in with COVID, as well as the time that we are in at the moment where we're getting into the festive season, and we all know the bad things that happen during festive season. Okay, so let's have a chat about why you should have a will. So here's the scary statistic that the High Court estimates that about 70% of working adults in South Africa does not have a will. 70% of working adults. That is a scary statistic, that only 30% of people actually have a will. So why do people not have a will? I think a lot of the reason why people don't do wills is firstly because they are scared. A lot of people have this idea that if they start thinking about death and what needs to happen, they're going to create that. So they're scared to talk about death. They're not comfortable with death. And I think the whole COVID pandemic has made us realize that the reality that death is actually a big part of life. So hopefully through this pandemic and through this crisis that we are going, people understand and start to learn that these things are important. The second thing I think why a lot of people don't get their will sorted out is they think it is more complicated to draw up a will than it actually is. So it's actually not that complicated. It's actually quite a simple process to draw up your will. So it is so important for everyone that's listening to this show, go and get your will sorted out. If you have you don't know where to go, you can email us at info@retirehappy, and we will get somebody to come and talk to you and get your will sorted out as quickly as possible. Also, why it's important is that the festive season is upon us, and we all know what happens on our roads during the festive season. And I know we think that it's not going to happen to me, but it could. So it is important to get your affairs in order. Make sure everything is sorted out so that you don't leave your family behind with all these issues and headaches. So let's go through a few reasons on why it is so important to have a will. So the first reason, and this is the main reason why you have a will, is you need to make sure that your assets actually reaches the intended recipients. So most of us have children, we have a spouse, we have dependents, and even if we're not married, we have family members that we would like to leave our assets to. If we don't have a proper will in place, then the law kicks in and they then distribute our assets according to legislation. And that could be or end up people getting assets that you don't want them to get. So it is so important that you make sure that your will is sorted out so that your children and your wife actually gets what they need to get. The second reason is, and this is very important, it is to save your loved ones from time, money, stress. If you die intestate, the time it takes to get your estate wound up escalates. It's like 2-3 times longer to get the estate wound up. That can put untold pressure on your family, because while that will is being or that estate is being wound up, a lot of the assets, money, life cover that might have paid into the estate cannot be paid out to your spouse and your children to make you them be looked after. So it's important to have a will to get that process done as quickly as possible. I've seen widows having financial struggles, losing their houses, having to move because money is tied up in an estate that is not wound up, and it takes 3-4 years to wind up the estate. They end up losing their house because they can't have access to the funds in the estate to help them. You don't want that situation to happen to your loved ones, because having a proper will also speeds up the process. If you have a proper will, depending on the size of your estate, it could take anything between 12 and 18 months to wind up the estate. If you don't have a will, that period can double to 36 to 48 months to get the estate wound up. So it can be a much more complicated and long-winded process, and the stress that puts your family under is massive. Also, from an expense perspective, it can become very expensive then for them to get the will wound up. Okay, so the third one is your will appoint the person who will manage your estate. That person is called your executor. The executor will take over the managing of the estate, and that executor will then handle everything. Okay, so if you have a proper will, you choose who your executor will be. If you die intestate, the master of the Supreme Court will then appoint an executor to your estate, which is not always an ideal scenario. So if you really love your spouse, your wife, your husband, please don't make them the executor to your estate. Rather get a person or a company that this is what they specialize in. Guys, being an executor on an estate is a very complicated process. It's something that you need certain skills, contacts to get these things through. I've seen it as well where the husband becomes the executor on the wife's estate, and then for months he battles just to get the appointment at the master to become the executor. That takes months to happen because he hasn't got contacts in the master's office. Where companies, and we all know how the bureaucracy in South Africa works, you have to smooth the gears to get everything done because all the departments are like very, very slow. So by getting a company involved that actually knows what they're doing, work with us every single day, these things just happen so much quicker. If you do it on your own, it can extend this period dramatically. Also, what happens if you appoint your spouse or a family member with no financial background as the executor to your estate, what will typically happen is the High Court will refuse to give him executorship unless he's supported by some attorney or some legal representative. The problem you have with that is that attorney is not limited to the legislative cost of winding up an estate. An executor, there's only so much executor's fees that can be charged. It's limited at a percentage, which is 3.99% of the estate, excluding VAT. So the executor can't charge more than that amount to your estate. Where if the spouse is the executor and they have to get an attorney involved to help them wind up the estate, this attorney is not limited to that cost. So the attorney will then charge at attorney-client cost. So, and that can be much more expensive than just having an executor run the estate. So, guys, if you look at it, the executor, make sure that you get a reputable company that has worked with us before to get or to become the executor of the estate. On that point, let's just look at the different personalities that you have on a will. Because people get confused. They get confused between an executor and the trustee on the will and the guardian on the will that is specified on the will. Especially executors and trustees. People get confused. So they say, no, but I don't want a company to be the executor because I'm not sure that they will be able to look after my children. Well, the executor doesn't look after the children. The executor's job is to make sure that the estate is wound up. The executor's job is to handle the assets, pay the liabilities, make sure that everything is done, and then pay out the balance of the estate to the beneficiaries. Then the executor's job is done. The trustee's job is to then, or through the executor's job, is also to set up a trust if there is provision in the will for a testamentary trust. The executor then sets up the trust and appoints trustees to manage the trust on behalf of the minor beneficiaries. So the trustee will look after the financial well-being of the children moving forward, not the executor. The executor's job is just to get the estate wound up. So it's very important that the executor is a company or somebody that actually runs with these things every day or every month. The trustee is somebody, I usually suggest that when you look at a trustee for the trust, then you set up a private individual, somebody that you know would have the children's best interest at heart, and you put a financial institution or a financial person, financial advisor or accountant, auditor, somebody like that, or a company that manages these as the trustees of that trust. And the reason I say both is, if you look at those two personalities, the individual person knows your children and they will look at it from the point of view of what is in the best interest of the child. The company, the financial services company, will look at it from a purely financial perspective. They won't look at it from an emotional perspective. So they will look at, does this decision make financial sense to do? And between the two, I feel you'll get a much more balanced decision making for your children going forward, because somebody who's emotionally involved may only look at it from the point of view of the children and overspend or make financial decisions that's not always positive for the trust, where the financial institution might look at it purely from a financial point of view, but not take into account what the actual children's needs are. So between the two, there's I think a more balanced approach. Then we get the guardian. I see this quite often as well, where people make the guardian of the children also the sole trustee of the trust. Guys, that is very dangerous, because what you are basically doing in that scenario is you are giving your children to a person, and yes, I know you wouldn't have given your children to a person as guardian that you don't trust. But we never know how people react and respond when they suddenly have access to millions of rand. You never know how people respond. People justify them. Some of the greatest people in the world have gotten into trouble before because they keep justifying what they're doing. And before they know it, they've mismanaged all the funds because they didn't have the knowledge, or they just got overwhelmed with all the money. So then they make the guardian and the trustee the same person, which then means that not only does that person have responsibility to the children, but they also have access to all the funds without any checks and balances. So it is important that you don't make a guardian the sole trustee. You can make a guardian a co-trustee, but I won't make them the sole trustee. I'll always have a financial institution as part of that as well. Also, and as I discussed with the guardian and the trustee, as part of your will, you choose who will look after your minor children, which is quite important. It is important that you give it some thought, because these things do happen. So in your will, you will appoint guardians for your children. Now, typically, if one of the parents pass away, automatically the other parent becomes the legal guardian for the children. Even so, let's say you are divorced and your husband stays in a different town and he sees the children. It's always the husbands that move away. I don't know why I'm picking on the husbands, but so the husband stays in another town and the kids see him once a month or so. And if you had to pass away, even if you say, no, but my sister needs to look after the children, the law states that the biological parent becomes the guardian automatically. So even if you state in your will that you want your sister, as long as the children has a biological father or another biological parent, they will become the guardian of your children. But if you and your spouse passes away together, then automatically those children needs to be placed in guardianship, and you do not want to have a situation where that is not nominated. Also, before you put people on as guardian, make sure that you've had a discussion with them. Make sure that they understand the responsibility that comes with that, because again, we go through life thinking that it's not going to happen to us. But these things do happen. We've seen it happen in the last 18 months of what we have gone through. So it's important that you have these things set up in your will. You've discussed it with people or with the guardians, and they know and they've accepted that responsibility. You don't want a situation where you might pass away and suddenly people get your children, which they weren't expecting. They didn't sign up for this job, and then there's that resentment that they have because they now have responsibilities that they didn't want. Also, the effect that could have on your children is very, very negative. Okay, so the will help you choose who will look after your minor children. Another thing that a lot of people don't think about in their will is your will also be a place where you can specify what needs to happen to your pets. Because what happens to your pets? You have 2 dogs, you have 15 cats, if you're a cat lady. What happens to all of these cats? What happens to your dogs? So in your will, you can actually state. Now, you cannot in South Africa leave assets to your pets. I know in America and overseas, you hear about a billionaire leaving 10 million rand or $100 million to their pets. South Africa, a pet is seen as property. So you can't leave assets to a property. So you can't go and say, my house, I'm going to leave my house 10 million rand, because the house is a piece of property. That's how they look at pets in South Africa as well. So you have to then give your pets as a property, as an asset to a specific individual. So again, as with your children, talk to people and make sure that they understand that you have been thinking of doing it. And they understand and accept the responsibility, because again, you don't want a situation where people who actually are allergic to cats suddenly inherit your 15 cats and they weren't expecting it. Not a good situation to be in. Another one is it lowers the potential for family disputes by having a will. I think all of us have heard the stories of people fighting, but my mom told me I can have that ring, and then the other daughter says, no, she told me just before she passed away I can have the ring, and then it creates this family animosity. So by having a proper will drawn up, it limits the chances for family disputes. Saying that, it is not necessary to overcomplicate your will. Guys, keep your will as simple as possible and as easy to understand as possible. The more in detail you go into your will, the more chances for disagreement and misunderstandings there can be. So keep it as simple as possible when you do draw up your will. Okay. Through your will, you can also support causes and leave a legacy. So you can decide what your favorite charity is, and you can take that and leave money to that charity. You can even go as far, if you want to support a charity or a good cause, you could even go as far as taking an amount per month, taking out life cover and leaving that life cover to a specific charity. So let's say, for example, you are willing to spend 300 Rand a month on a specific charity that you want to support, you can take that 300 Rand, take out life cover on your name, and make that charity the beneficiary for that life cover. So what then happens is when you pass away, they get that total amount of life cover. So that is a way that you can leave a legacy, or support a good cause that you supported while you were alive. Just be careful. So it's important to speak to a will specialist or a financial advisor, because you just have to be careful that you don't create an estate duty liability in your estate if you do something like that. But it is something that you can do through your will as well. Again, if you don't have a will while listening to this and you need to get it sorted out, you are welcome to email us info@retirehappy.co.za, and we will send somebody to contact you to come and sort your will out. Okay, the next one is, I know that it sounds almost like obvious, but you will be able through your will to provide funeral instructions as well. So it's important that that is sorted out through your will, and that can be put in there, the funeral instructions. Do you want to be cremated? Do you want to be buried? Do you want your ashes put somewhere specifically, etc., etc.? Okay, we've got a question here from Warren. Can a husband and wife have a combined will? Warren, yes, a husband and wife can have a combined will, although we tend to rather split it up so that each has a separate will. That is the reason for that is if the husband dies and then the wife doesn't have the chance to change her will and she dies soon after, it can create some problems with where the money eventually ends up. So it's ideal, we'd rather put it as two separate wills. It is much easier, but there's no legal thing that says a husband and wife cannot have a combined will. Fricky says, I have a will written by hand and it is in my safe, and I told my children about this. Is this okay? So there is certain specific things that make a will valid. One of it is that it has to be written, and it doesn't have to be typed, but it has to be written, so you can write it by hand. That is fine. But secondly, there's a lot of things that needs to be done on that will. So it has to be signed by yourself. It has to be signed by witnesses that were present when you signed the will. Also, there's certain things in that will that needs to be stated from a legal perspective to make sure that there's no issues when submitting that will to the master. So yes, technically you can have a will written by hand if it's properly signed, properly dated. But our advice is to rather have it properly drawn up by somebody that knows what they're doing, because there's small clauses that is important. The setup of testamentary trusts, the fact that your executors has to doesn't have the need to provide security to be appointed an executor, which can create a massive issue if they don't. So if you don't have that in your will written by hand, suddenly the executor that needs to be appointed has to provide security for the assets that they're going to have under administration, and that can create a hang of a lot of trouble for you. So yes, technically, Fricky, the answer is yes, you can. It is okay, but our suggestion is rather get somebody that draws up a will properly, so that you know that all the I's are dotted and all the T's are crossed, and you don't have any issues when you pass away to have that will validated. Another thing I'm going to chat about a little bit later is a living will. Should you have a living will? What is a living will? And what is the risks involved, because a lot of people are afraid to sign that living will. So let's quickly go through the last few reasons to have a will. A will also help you set up a trust for your minor children and choose the trustees. Like I spoke about earlier, the trustees, the executor is there to wind up the estate. The trustees are there to manage the finances for your minor children in a trust. So through your will, a testamentary trust is set up. So this is something I see quite often when we start working with clients, is that either somebody has sold them this idea or they are thinking that they should have this in place. We get people that say, well, I've already set up a trust for my children, so when I pass away, the money from my estate will then be paid into the trust to be looked after for my children. Or they ask me, should we already set up the trust? Now, guys, there's two types of trust. You have inter vivos trusts and you have testamentary trusts. So although both are trusts, they are handled differently. So today is not the space to go into a lot of detail with it. What you just need to know is that an inter vivos trust, the one that you set up before you pass away, because you can't set up a testamentary trust if you're still alive, but the one you set up before you pass away, the tax on that inter vivos trust is much worse than the tax on a testamentary trust. So it is better to just in your estate or in your will set up a testamentary trust. Now all wills, if you have them drawn up professionally, will automatically have a clause in that says a testamentary trust needs to be set up. So rather do it that way. Don't set up a trust beforehand if you have no other reason to set up a trust. If you have businesses and properties and things like that and you want to do that through a trust, that's a different story. But if you want to set up a trust now for the sole purpose of taking control of the assets that needs to go to your children if you pass away, that is not ideal. Rather do it through a testamentary trust. Because firstly, you're still going to pay fees on that inter vivos trust even though it's not being used. And secondly, the tax is not ideal on an inter vivos trust against a testamentary trust. So rather have a testamentary trust set up. Also, when you do set up the trust, you can choose at what age the trust needs to mature and the money needs to be given to your children. So you can do it up to age 18 because currently in South Africa you are an adult and have all the powers of an adult when you reach 18, where in the past it was always 21, now it's 18. Or you can choose to extend the trust to age 21 or to age 25. My suggestion, and again guys, this is not it's right or wrong, this is just my point of view, is that you make the trust up to age 25 at least for your children. Because let's be honest, what do you really know about life and about your about money by the time you are 21 or 22 years old? So if you get 3 million, 4 million, 5 million rand by the time you are 18, chances are very high that you will probably mismanage and lose that money. So we always suggest that you keep that trust running until age 25. That doesn't mean, because this is what scares people, they say, but that means my child doesn't have access to the funds. That doesn't mean your child doesn't have access to the funds. Let's say they want to start a business when they are 22 years old, the trust runs till 25, they can then go to the trustees and ask the trust for funding to start a business. The difference though is now they are getting advice from the trustees. They can't just take the money and put it in the business and lose everything. They will get advice, they will get guidance from the trustees. They will have to put a proper business plan in place, etc., before the trustees will allow them to get access to the money. So they have to then justify their access to the money, and for me that is worth a lot, because now I know my child doesn't have to make those decisions completely on their own. So I believe that you make that trust until age 25, and then they can have access to the rest of the funds in that trust. Okay, the 10th one is through setting up your estate properly or your will properly, you can also minimize your estate duty and minimize any capital gains tax liabilities. Guys, we tend to think that the cost on estate is only executors' fees and estate duty. There's a lot of other costs involved in winding up an estate as well, and those costs can eat up a lot of the assets that you have worked very hard through your life to build up for your beneficiaries. So set up your will properly to minimize those effects. Don't have all your life cover go into the estate. Just enough money has to go into the estate to pay for executors' fees, to pay for estate duty and any liabilities that are in the estate. The rest you can pay directly to your beneficiaries, so that the money that is deemed asset in the estate, that is going directly to the beneficiary, doesn't get used to calculate the executor's fees on the estate. So it is important that you set up your will properly. So sit with a will specialist, let them look at your estate and calculate what the costs involved is. There are products, we also have those products that provides cover for estate costs. It's a small little, basically a life insurance product, but it's a very specialized life insurance product specifically focused on covering estate costs. So what that means is if you pass away, that cost is paid, so you know the assets that you've built up actually gets to your beneficiaries. It's not eroded by all of these hidden costs. There's costs like clearance certificates on the municipalities. There's transfer fees on the properties. There's capital gains tax that needs to be paid. There's a lot of these costs that needs to be paid. So that small little product just makes sure that the assets that you've built up gets to your beneficiaries at the end of the day. But what are the requirements of a will? What makes a will valid or not valid? And this ties into Fricky's question about a written by hand, a handwritten will. So the first requirement of a will is a person who has a will must be 16 years or older. So you have to be over 16 years old to have a valid will, because a will is a contract. So you can only sign that contract when you are 16 or older. So you can't draw up a will if you are younger than 16. Secondly, it has to be in writing. That doesn't mean it has to be typed. It doesn't mean it has to be in a specific format, but it has to be on paper in writing. You can't just tell somebody, listen, my wishes are X, Y, and Z, and then expect that to be a legally binding contract. So it has to be in writing. Like I explained to Fricky earlier, it is better to have everything done professionally, because you just make sure that all the small things are sorted out and in place. Number 3, you have to be mentally capable to go into a legal agreement for the will to be valid. So a person who starts suffering from dementia can be classified as not mentally capable, which means they can then not sign a will, or that will can be disputed if it was signed after they were diagnosed with something like dementia, for example. Number 4, this is quite important. On the will, you have to have 2 separate witnesses sign the will with you. If you don't have witnesses sign the will signed by 2 witnesses, that will not be accepted by the master as a valid will. So it is important. Those witnesses have to be 14 years or older. So they don't have to be 16 years or older. They have to be 14 years or older. Very important though is nobody that is a beneficiary at any point on the will can sign as a witness to the will. So you can't have your wife sign as a witness to your will. You can't have your children sign as a witness to your will if they are specified as beneficiaries in your will. Also, each page of the will has to be initialed. So every page at the bottom needs to be initialed by yourself, the testator, as well as the witnesses. And everybody has to sign the will in the presence of each other. So this is sometimes a bit of an issue to get witnesses to come so that they can sign the will. So it has to be in the presence of each other. And then very important, guys, this is something that is actually, it sounds obvious, But I see it so often. We sit starting to work with clients or students. We get a copy of the will. They're very, very proud of themselves that they do have a will and it's signed. They come and give it to you. And then when we read through the will, we see that that will has never been dated. So the will is signed, but there's no date on the will. That makes the will invalid, because how it works is you don't have to cancel one will to replace it with another will. The first sentence of a will says, this will replaces all previous wills and codicils, which then means that this is my newest will. But if it's not dated, how do they know which one is the newest one? So you have to date that will, and I see that so often, and it's such a simple thing. It has to be dated. You have to make sure that that will has a proper date on, so that if there's 2 or 3 wills that come, they have to be able to know which of those wills are the most recent one. Okay, then lastly, we have 5 minutes. Let's quickly talk about the administration process. I'm going to run through this quite quickly. So if you have any questions on it, you are welcome to email me at lawrence@retirehappy.co.za. You're welcome, if you need a will or you need to chat to somebody about your will, email us at info@retirehappy.co.za, or give our office a call at 087 809 0603. I'm going to say that again, 087-809-0603, and we will get somebody to help you get your will sorted out. So what happens when a person passes away, or when you pass away for the winding up of the estate? The first thing that happens is a consultation needs to be done between the executor and the beneficiaries of the estate. So the documentation, so it's usually the spouse or the dependents, there's documentation that needs to be signed so that the estate can be registered. And that estate has to then be registered with the Master of the Supreme Court within 14 days of the person passing away. Once that is registered, the master will then issue a letter of executorship to the executor. So the master will look at everything, make sure they are happy with who the executor of the estate is going to be. And if it's a company that does this for a living, that usually takes a shorter period of time. If it is a family member, they might have requirements before they are willing to issue that letter of executorship. But once they've issued the letter of executorship, the executor can then act on behalf of the estate. So the moment that letter of executorship is given out, that executor then becomes the decision maker for that estate. So there's a couple of things that executor can now do on behalf of the estate. The first thing is the executor can open an estate late bank account for the estate. So if any life cover needs to be paid into the estate, it has to be paid into that estate late bank account. So before that happens, the life cover doesn't have anywhere to go. So if there's not a proper executor, there's not a proper will, this could take months, which means the life cover cannot go anywhere, which delays it and which allows families to suffer financially. So they can open a bank account. They will then notify all third parties of the death and the fact that they are now in charge of the estate, so that those third parties can then come and put any claims that they might have against the estate to the executor. Also, they will start drawing up a statement of assets and liabilities, and then any other actions that needs to be made or done on behalf of the estate. The purpose of the executor is to eventually draft a liquidation and distribution account, an L&D account, liquidation and distribution, which says these are all the assets in the estate, these are all the liabilities in the estate, these are all the other costs, including executors' fees, capital gains tax, estate duty. The whole breakdown of that estate is then calculated on the liquidation and distribution account, and then the estate duty is calculated after that and paid over as well as the tax return, the final tax return for the estate, and the capital gains tax on any assets is calculated and then paid. Now you can see that's the first thing that get paid is the estate duty, the capital gains tax, and the tax that's outstanding, of course. Before anything else happens, the government first has to get their cut of the money. Once all of that is done, they will then lodge the liquidation and distribution account with the Master of the Supreme Court, which will then go through, make sure that everything is above board and everything is fine. If there is no issues with that, the Master will then accept those liquidation and distribution accounts, and the executor can then place ads in the Government Gazette of local newspapers to say that this is the liquidation and distribution account for this estate late, and people can then again put in any claims or dispute the figures on there. It is also, those will be that liquidation and distribution accounts will be available for inspection at the Master's office. So you can go and actually go and have a look at it if you have any dispute against the estate. Once that has been running for 21 days, business days, and there was no objection to the liquidation and distribution accounts, the Master will then issue a certificate of non-objection. So the certificate of non-objection says the Master is happy. Nobody came and said there was a dispute or there was an issue with the estate. So they are happy that everything is done above board. And after that, they will then create a final letter from the Master saying that this estate has now been wound up, and then the executor can pay out any assets to the beneficiaries, or any monies that needs to be paid gets paid to the beneficiaries. This can take anything between 12 months to 18 months. We've had estates take less than that, but usually about 12 to 18 months. In this whole process, if there's any disputes or the will gets disputed, then this can be delayed for 36 to 48 months. So you want to make sure that these things are done properly to get everything sorted out. Guys, that is our discussion for today. Hi guys, Lawrence here. Thanks for watching this video. I hope you found it informative and you got some benefit out of it. Please add in the comments any questions you might have or any other topics that you would like me to talk about. Please subscribe to our channel, hit the bell button so that you can get notified of any new videos that we post so you don't miss anything. Thanks guys, see you around.